Please be seated. We will just swap.
Welcome back. And I would like to start this session with another question to the representative of the Republic of Kenya, if I may. If I understood correctly what you said in the previous session, Kenyan law, Kenyan law makes distinction between judicial request and non-judicial request. And judicial request, you need a court order, while non-judicial request, you don't need. And in Article 93(1) of the Roma Statute, there are various types of requests from the court enumerated from A to L. In your interpretation of Roma Statute, some of them are judicial requests and some of them are non-judicial requests. Am I right? I'm asking because there is also a dispute between the prosecution and the government of Kenya about the legal basis of the prosecution request for financial information. Prosecution's view is that this request was made on the basis of 93(1)I and L, while Kenyan government interpretation is that this request was made based on 93(1)K. Will that make any difference?
Your Honors, it is indeed true. It is indeed true that Article 93 contains both judicial and non-judicial requests. But on the main, in substance, it enumerates judicial requests. That is to say, it requires, for example, on the main, the taking of legal action within the state party. And in most of the provisions they are set out, it requires the invoking of domestic legislation or law. If, for example, you look at 93(1)A, the identification and whereabouts of persons or the locations of items, it requires no judicial intervention of any nature because it can be complied with simply by the state party providing information, say on the location of the scene of the subject matter of the proceedings, or the identification of persons. For example, if we received a request that asked, in Kenya, under your management of government, tell us who is responsible for the registration of persons or the issuance of passports. There is no requirement for a court order, and we would be able to comply with that. That is also true in the main. If you go to I, the provision of records and documents, including official records and documents. There are many records and documents held by the government that do not compromise the privacy or the personal rights of any person. In fact, in these proceedings before this court, we have already, if I remember correctly, the prosecution requested of us to provide documents indicating ownership of certain motor vehicles. We did that. We don't need a court order. There is no privacy about the ownership of a motor vehicle. It is a matter of common and public knowledge, and that's why we complied directly. On the main, however, 93 requires certain other facilitation that call for judicial support. For example, facilitating the voluntary appearance of persons as witnesses or experts before the court is a matter within the consent of the person. The court will say, we understand that in Kenya there is an officer called the chief government chemist, who is a person who runs the government's laboratories. He has agreed to come to The Hague to talk about this process that he carried out. Can you facilitate? That means, can you issue him with a travel document? Can you give him leave from his work? We don't need a court order, because that is within our mandate, especially if he confirms. However, if we require the questioning of any person being investigated or prosecuted, a whole regime of the statute itself and of Kenyan law kicks in. Because this person being investigated or prosecuted has rights under the Rome Statute, under the procedures of this court, and indeed under Kenyan law as well. A Kenyan court asked to question any person, because it is a judicial process. I cannot call this person to my chambers and question him. It would be worthless, because I'm not a judicial officer. If I took a statement from a witness, it would be worthless, because I am neither an agent of this court nor a judicial officer. And that process under Kenyan law would be of very little value. And if the person from whom I have taken a statement were to dispute the contents of his statement, then you can see, Madam President, it's a Pandora's box. The correct way to do it would be to have this process referred to, which is what we've done in the past, referred to a judicial organ, and that judicial organ then uses the normal rules of an investigation and prepares evidence taken under oath. Nobody else can take evidence under oath for purposes of supporting a judicial process. So my short answer to your question is this. It is true that 93 contains both sorts of procedures. And it is also true that the prosecution misdirected itself in believing that all these processes could be treated as similar. And before I wind up, if you look at I think I is very instructive, Your Honors. And if I may read it, it says, any other type of assistance which is not prohibited by the law of the requested state. Any other assistance. My own understanding of the rules of statutory interpretation are this, that where the statute clearly enumerates the draftsman intended that each article be appreciated as such, And where there is a general provision of this nature, it is also to be understood in the context of its limitation. Any other assistant not set out in 93(1)(a) to K can only be made if it does not contradict the law of the requested state. What has happened in this case? The prosecutor has made a request, which in our interpretation is a 93(1)(I) request. And we have said it is prohibited by domestic law. In our view, nothing could be clearer. That is a prerogative of the receiving state to interpret its own law. In fact, the reason we are here before you today, Your Honors, is because the prosecution has done something unprecedented in international judicial proceedings. It has sought to impose its own interpretation of the law of another jurisdiction on the officers of that jurisdiction whose constitutional mandate is to make the interpretation. I have in my experience, which is not as extensive as that of the honorable judges of this court, but is close to 3 decades of the law. I have always understood the law to be that an international tribunal cannot purport to interpret the law of a sovereign state in a manner inconsistent with the way the organs of that state interpret that law. And this court, or indeed any other international tribunal, should not place itself in a situation where the Supreme Court of the United States has declared the law of the United States to be X, or the Constitutional Court of Germany has declared German law to be X. But the International Criminal Court declares that domestic law to be something else. That would be a recipe for disaster. And international jurisprudence is consistent on this point. In Kenya, the Attorney General is the chief legal officer of the Republic. His interpretation of law is final, except where the same dispute is referred to a judicial organ that overrules that interpretation. So, as we sit here this morning, the law of the Republic of Kenya has been stated by the Office of the Attorney General. Thank you.
Thank you very much, Mr. Attorney General. And please rest assured that nobody in this court would like to try to impose any specific interpretation of your law. But at the same time, this is for this court to interpret and adjudicate the Roma Statute and whether any acts of anyone are consistent with the Roma Statute or not. The related question, as for this judicial request, in order for you to get a court order, do you always need an order from the chamber of International Criminal Court? I ask this question because in some jurisdiction, in the context of international cooperation on judicial matter, some jurisdiction Attorney General can get a court order upon the request from the competent authority of requesting state, which is not necessarily court.
Thank you very much, Your Honors, for the opportunity to make this clarification, which is contained in my filing of yesterday. Under the constitutional law of Kenya, all criminal processes, the representation of the government of the Republic of Kenya in any criminal case in Kenya is the absolute mandate of the Director of Public Prosecutions, who is an independent constitutional office, and as I have extensively set out in my written submissions, is not subject to any direction by any body or authority. And as your honors will, when you retire to consider all the written material, as your honors will find out, this is at the heart of the argument that the Republic of Kenya is making about cooperation. Because if I received an order from you, for example, I would receive it as the competent authority under the statute to receive the order. But then I would have to surrender it to the constitutional organ in Kenya that has the mandate to represent the government of Kenya in any criminal process. And let me come back, with your permission, to the example I gave you earlier. When you gave us the warrant, when this court, in its corporate sense, transmitted to us the warrant of the arrest of a Kenyan citizen alleged to have interfered with witnesses, I and the Minister of the Interior received the warrant. We then jointly transmitted the warrant to the Director of Public Prosecutions. Why did we do that? Because Kenyan law says that in all criminal proceedings or proceedings of a criminal nature, the Director of Public Prosecutions has constitutional mandate that he doesn't share with any other person. So that as we speak here today, Madam President, that process is going through the courts under the stewardship of the Director of Public Prosecutions. I have no constitutional authority. The President has no constitutional authority. The Minister has no constitutional authority to direct him to do it, to stop doing it, to halt, or interrupt, or do anything else. That would be a violation of our law and our Constitution. And I know that the time to discuss what was alleged to be the interference by the head of state in the process is coming. But this is the basis of the misunderstanding. There is a misunderstanding that in Kenya, all we need to do is to receive an order from a court. Then it is effected directly by the recipient. I can't do it. If I received an order about financial records, I would have to go to the governor of the central bank, an independent institution under the Constitution. And it says so in the Constitution. The Central Bank of Kenya shall be an independent institution that cannot take instructions from any other body or authority. The same is true of court. Many times I have been asked by the prosecutor, give me a file of a case that was conducted in a certain place at a certain time. And all I have been able to say is, I have transmitted your request to the registrar of the High Court of Kenya, who cannot take instructions from me as to what they will do in their judicial capacity. So I wish to confirm, therefore, that this would have to be placed before the constitutionally mandated authority. And that is the normal procedure in Kenya. Thank you.
I'm sorry, Mr. Attorney General, I'm a bit confused. As for Central Bank of Kenya, if there is a court order, order from the Kenyan court, they are under obligation to disclose certain materials. Am I right?
the Central Bank of Kenya is the regulator of banks, all banks. And in terms of processing requests, we would send that sort of request to the regulator. Then the regulator would send the request to the specific bank or banks. In theory, it is expected that the Central Bank of Kenya would have access to information or would have the authority to require information from banks. But banks themselves, in responding to the central bank, would have to comply with the Banking Act, which itself says no information may be disclosed except with the consent of the depositor or the client. So that is the problem. May I clarify something that you asked me earlier, and my mind was not firmly on it, and it is this, Madam President. You asked me whether I ever approached Mr. Kenyatta for this purpose, or Mr. Ruto, indeed, for the general purpose of the request. And I told you I didn't, and I gave you the reason then. As I had coffee, I thought of another reason as well, even more fundamental. The request to supply information relating to the financial records of the two accused persons was done confidentially. And had I used communication given to me confidentially by the prosecutor?
Mr. Attorney General, this is open session. Do you want me to go into closed session or private session?
No, we have since, Madam President, the prosecution and ourselves have since discussed the matter on record.
Okay.
Yeah, and we agreed that there was a mistake on the part of our first filing, which we disclosed. This court reprimanded us for having disclosed the information, and we were apologetic. It was a mistake, but now it's a matter of public record. But I have explained why it would have been a violation then of the treaty and the rules of this court to have discussed it with the other parties. Thank you.
Thank you very much. Another related point, I see, for example, in Article 79 of International Crimes Act of Kenya about producing documents or other articles. I think this article corresponds to Article 93(1)(b) of the Roma Statute. The Article 79 of International Crimes Act says, if the Attorney General gives authority for a request relating to the production of documents or other articles to proceed, a judge of the High Court may make an order requiring their production. Does this mean, for example, if the request was made on the basis of Article 93(1)(b), your office will process this request and send it to the judge of the High Court, and judge of the High Court may make an order requiring their production? Is that correct interpretation of the law of Kenya?
That is not correct. What is correct, Madam President, is this. If the Attorney General is satisfied that a request for the production of documents or other articles is regular, is consistent with the Rome Statute and Kenya's own law, then what ought to happen is that the Attorney General ought to direct whoever is responsible for the maintenance of these records to produce them. Supposing, for purposes of argument, that person didn't or didn't do it timeously, in in furtherance of the cooperation required of the Attorney General can notify a judge of the High Court that we have been requested by the prosecutor of the International Criminal Court to provide the following information.
Mr. Attorney General, I'm so sorry to interrupt. You are speaking too fast, and interpreters are having difficulties. Could you just a little bit slow down?
Can I start again then? Madam President, Section 79(1) of the International Crimes Act envisages a situation where the Attorney General has been persuaded that documents or articles required by the court, or for this purpose, the prosecutor, ought to be released to the prosecutor. And I'm using the example here of the registration of motor vehicles, which is because it is an item we have already dealt with the prosecutor. If I have made that determination and I forward my recommendation, my instruction to the registrar of motor vehicles, and I say, release to me immediately the logbooks copies of the following motor vehicles. Supposing he doesn't do it, it means that the obligation now is in my hands to approach the court, and therefore the court can make an order. And you have to look at the language there again. The language there is may. The language is may, meaning the court itself, to whom I have complained that the director of motor vehicles hasn't given me documents, can itself reevaluate afresh whether I had made the right decision. The court is under no obligation to go by my order. The distinction here, which is important, Your Honors, is that in respect of an application, under 93 of a judicial character, the consent of the court must be sought ab initio. The intervention of the court must be sought from the very beginning. And let me give you an example. (93)(1)(h). The execution of searches and seizures. If I received a request for the execution of a search and a seizure order, I would have to process that within the domestic law of Kenya, because I would have to call the Inspector General of Police and say to him in a communication, we are required by the International Criminal Court, by this warrant, by this order, signed by these judges in this manner, for you to conduct a search and to seize whatever it is. That is a process that the Inspector General himself, because he would be looking at a court order from here, would be required to enforce within the domestic machinery of the criminal justice system in Kenya. And therefore, that is a different problem from the one anticipated by 79.1. I hope I have answered your question.
Thank you very much. I may be repeating myself, but I appreciate if you can help me. Let's take example of bank records. If this chamber is to make an order for production of the records of the bank, it's chamber's order, not prosecution request. What will happen for you to go to central bank, and central bank will contact with relevant banks, and if banks cannot produce the required documents because of bank secrecy law or whatever, then someone in your government, it may be you or prosecutor general, will go to the Kenyan court to get an order in order to comply our request. Is that what will happen?
I'm afraid, Madam President, that is not very accurate. The accurate sequencing would be as follows. If there was a proper application before you, made in the proper manner, and there was an appropriate order of this court, the order would be received by me. And because it is an order in furtherance of a criminal investigation and prosecution, I would transmit those documents to the Director of Public Prosecutions. In my own understanding of the law, which I believe would be his as well, he would then place that order before the High Court of Kenya. And he would say in his application, I have received this order by the International Criminal Court asking me to obtain bank records relating to X, Y, and Z. I am mindful that I'm required to execute this order in accordance with the procedures of Kenyan law. And therefore, I have come to this court to request this court to give me an order that I will serve on the central bank, and where we know the relevant banks, the specific banks requiring this information. The minute the DPP initiates that judicial process in Kenya, two things may happen. A, the Kenyan court may, ex parte, without hearing any person, grant that order. Or B, the court may require that persons affected by that order be given a right of hearing in respect of the proposed process. So, in short, Madam President, you are right in the general sense that we would require to have a domestic process, but the sequencing is different. We don't begin with the order from the court and serve it. We begin by taking the order of the court to a Kenyan court. I must add this, with your permission. I have looked at several statutes in other countries domesticating the Rome Statute, and the procedure is consistent. I have looked at the procedure in South Africa, in Australia. It is consistent. There are those things that will not be done without a domestic court process. And there are those things that can be done without a domestic court process. Thank you.
Thank you very much. Judge Henderson has a question.
Yes, thank you, Good afternoon, Mr. Attorney General. Thank you very much for coming here to assist us as we grapple with this issue of the issue before the Court of Non-Compliance. I want to ask some questions, essentially to, if I may, tease out ultimately who is responsible for the execution of requests, as I think this is integral to us understanding the process, and it also featured significantly in your written submissions, which we received yesterday afternoon. So perhaps, if I can just catalog some of the provisions which I thought might have been relevant, but ultimately, as you persuade us individually and collectively, I think this may be helpful. So we looked at Article 6 of the statute, which provides for the general obligation to cooperate. Looked at Article 88, which provides for procedures under the national law. I would have looked also at the legislation which domesticated the Rome Treaty, which is, I think, the International Crimes Act, number 16 of 2008, which locates within yourself, attorney, under Section 23, certain responsibilities for the execution of requests. And of course, I also looked at the Constitution of Kenya, which is the supreme law, and of course, there's a body of Commonwealth jurisprudence which locates and understands respective constitutional authority. And with respect to the Constitution, I looked at, if you'll just bear with me a moment, Section 132, subsection 1, which deals with the powers of the President under the Constitution, and in particular, subsection 3, which deals, if I could just quickly set it out shortly, chairing of cabinet meetings, directing and coordinating the functions of ministers and government departments. And then this important one, subsection 5, or subarticle 5, I beg your pardon, which also locates with him the ultimate responsibility under the Constitution of ensuring that international obligations of the Republic are fulfilled through the actions of the relevant cabinet sections and departments. So the question, which I therefore want to really seek your assistance on, is who ultimately is responsible for the execution of these requests? And if there are issues of non-compliance, who does one turn to? Because it can't be that, who does one turn to?
Thank you very much. I want to refer Your Honors to my filing, which you very graciously accepted to reclassify in the morning, because I have treated this question at some length. And I have done that on the basis that, and I don't want to rehash that argument.
Right, because it wouldn't enhance your argument or bolster it if you were to repeat it, because I can assure you we have read it.
Thank you. Thank you very much, Your Honor. Suffice it to say this, that one of the reasons I approached this court to allow me to come, as I have done here today, to address this question is because the prosecutor and the representative of the victims repeatedly said on record that the President of the Republic of Kenya, Uhuru Kenyatta, is personally responsible for failing to cooperate or force the machinery of state to cooperate with the court. I don't want to rehash again what I have said in my 31-page filing, except to make this point in a preambular nature. The President of the Republic of Kenya is not, has never been, and cannot be, under our constitutional dispensation, responsible for the compliance of the Republic of Kenya with any request. And the answer is a simple one. The Constitution of Kenya donates to independent organs of state. And I want to repeat that. The Constitution of Kenya donates to independent organs and officers of state authority and jurisdiction to deal with certain matters in a manner that does not require them to be guided by any other person or authority. And I have already given you an example, but I'm happy to give you another one and another one. And the first one is the Office of the Director of Public Prosecutions. The Director of Public Prosecutions cannot be instructed by the President to prosecute or stop prosecuting any individual. And I know, Your Honor, you have been yourself a Director of Public Prosecutions, and you would appreciate that. Madam Bensouda herself has been a Director of Public Prosecutions. It would be an anarchical situation in a democracy if persons were to be held before a court because the Director of Public Prosecution has been instructed by any other person, and he has done so without regard to the evidence and the law. I can assure you, in Kenya, it would not happen. Number two, take, for example, the Office of the Attorney General. The Office of the Attorney General is an office in the executive. But the constitutional mandate of the Office of the Attorney General requires the Attorney General to make independent, objective decisions. And that's why our Constitution says, as you have rightly pointed out, Your Honor, the Attorney General is the guarantor of the rule of law. Part of his job is to advise government on, but there is a separate, independent constitutional obligation to defend the rule of law. It is stated in this language, if I may. The Attorney General shall promote, protect, and uphold the rule of law and defend the public interest. The Attorney General cannot be asking other individuals in government, including other ministers, what is the public interest? Because the Constitution says it is his business to promote and uphold the rule of law, and he's deemed to know what the rule and the law is. I could go on and on and on. The President of Kenya cannot direct the Electoral Commission to declare a result in the election in one way or the other. It cannot. The President of the Republic of Kenya cannot advise the Judicial Service Commission to recommend one judge as opposed to another for appointment. And therefore, just to summarize, our Constitution is replete with independence and autonomy for institutions. And the President cannot assume responsibility for how those institutions function. But what about Section 1325 that Your Honor has drawn my attention to? What about the responsibility of the President to ensure that international obligations of the Republic of Kenya are fulfilled through the actions of the relevant cabinet secretaries? Indeed, that is the heart of the matter. If the drafters of the Constitution, and I must confess I was one of them, intended that this Constitution should impose on the President personally this responsibility, it would have stopped at that. The President shall ensure that the international obligations of the Republic of Kenya are fulfilled, full stop. It goes on to say, through the actions of the relevant cabinet secretaries. So what does it mean? I'm sorry, Honorable.
I also ask you to consider the impact or the relevance of Sub-Article 3, which deals with coordinating, because if there is an impasse or things have stuck, as it were, is everybody to sit on their hands, or is it that the general obligation to cooperate under the statute has to be given effect too? This is what I would like your help with.
Sorry, I appreciate that, Your Honor. If I have your permission, if I summarize on the first argument, then I'll come to that. The duty of the President of the Republic of Kenya in the fulfillment of Kenya's international obligations is to ensure that there is in place a responsible cabinet secretary for each purpose. For example, Your Honor, if Kenya is a party to the International Criminal Court Statute, the President of the Republic of Kenya is obliged to ensure that there is in his government an Attorney General to whom these requests can be transmitted. 1. 2, that there is a Minister for Foreign Affairs to whom the statute makes reference. And 3, to ensure that there is a Minister of the Interior to whom a specific request can be. The failure of the President's mandate would arise if he had failed to appoint responsible persons as required by the treaty and the law. In Kenya, there is no such problem. Is there an Attorney General? I am very happy to confirm to you, Your Honor, that indeed that is the case. Is there a Minister of the Interior? There is. Is there a Minister for Foreign Affairs? There is. In as far as the President's obligation under 1325 is concerned vis-a-vis the Rome Statute, he has discharged that obligation. What will the Attorney General do if he receives a request from the court? The President does not know. Nor should he know, because that is an independent function donated by the Constitution to the office holder. What will the Minister of the Interior do? The President doesn't know, and he doesn't need to know. What the President needs to know, and what he knows, is that there is an independent officer serving in that position. And I think the complaint that Your Honor can entertain in this court or in an international forum is to say the government of the Republic of Kenya is not living to its treaty obligation. Why? Because it is obliged to have an Attorney General to whom we can take a request. The President has failed to appoint an Attorney General. It is obliged to have a Minister of the Interior to whom we can take a request. The President has declined to appoint such a person. Thirdly, it is obliged to have a Minister of International Affairs to whom we should make, and the President has failed to do it. That then would be a failure of the President's constitutional mandate. Is that the situation here? Not at all. The three principal persons identified in the International Crimes Act as the persons required to interface with the court exist. And in addition, practically have been in communication with the court. In my tenure as Attorney General, I have dealt with three different ministers of the Interior. And I have seen every correspondence from the court to these three ministers. And there has never been a breakdown, right? I have dealt with three ministers of foreign affairs, and there has never been a breakdown. And each time we have received high officials of the court, I and the Minister of the Interior and the Minister for Foreign Affairs have been available for that purpose. An argument, therefore, that says that the President of Kenya conceivably can bear responsibility for what individually we are doing in furtherance to our individual mandate, either is based on a total lack of appreciation of our law or is just flippant. Now, you have asked me, Your Honor, what would happen if there was a total breakdown in the machinery for cooperation? I must thank you for asking me that question, because you have given me an opportunity to point out the exact circumstance that the drafters of the Rome Statute anticipated when they thought about a referral to the state parties conference. That is what can go to a state parties conference. That would be so fundamental. It would go to the heart of the state's commitment to its international obligation under the Rome Statute. I make no comment, because I assume I will have an opportunity to do so, as to what now the prosecutor purports as an afterthought can be taken to the state parties conference. I'll come to that. But let me, before I finish, make these points because they are in my submission, and I need to restate them. And they are this. I have been in the office of the Attorney General since September 2011. That date predates the date that the Honorable Uhuru Kenyatta was elected to be President of the Republic of Kenya. An argument that suggests that everything I did a year earlier, a year and a half earlier, 2 years earlier, was dictated upon by a person who had not assumed office is absolutely ridiculous, to say the least. How would I have anticipated that I should fashion my communication with the court in anticipation of an outcome of an election that even people more knowledgeable than I could ever be in those circumstances had confirmed was a contested election, legitimately contested election, meaning that there were persons running for those offices who had popular support. Finally, I want to place it on record because I have stated it in my statement. At no time did I receive or have ever communicated or received any direction or suggestion or prompting as to how my intervention with the court should be. I have made those decisions myself based on my knowledge and my experience and my learning, which a third lawyer or a fourth one may find to be inadequate, but I made them in good faith. Thank you.
I'm just going to ask you one last question, and of course give the other parties an opportunity to deal with the same point if presiding judge permits. What efforts have you, attorney yourself, pursued to ensure these specific requests that are at the heart, the number of this particular application today?
I must say, if what Your Honor means is what have I done about the requests regarding financial statements, nothing went beyond the final communication we had with the prosecutor in November 2012. The prosecutor stated her position, I stated mine. She stated she was entitled to the records, I stated that she wasn't. I encouraged her to take up the matter at an independent forum. She didn't. I considered myself then, as I do now, entitled to assume that the prosecutor was no longer interested in this particular disputed area of cooperation. Indeed, until the application for adjournment was made a few weeks ago, or rather a few months ago, this issue had become moot. It had become moot because two lawyers reading the same set of laws had come to two different conclusions in what the law required. I wasn't therefore in a position, Your Honor, to act in a manner inconsistent with my own interpretation of the law, and indeed my own conscience on this matter, because I never entertained a doubt then, nor do I do now, as I stand before you, that the prosecutor as a prosecutor is not entitled to this form of material without a court order. That is the reason I have not pursued the matter further. I hope I have answered your question, Your Honor.
Thank you very much. Now I would like to give. Now I would like to give the floor to the other parties and participants. But before that, I have a very practical question to ask Mr. Attorney General. So I understand that your position is that you need a order from this chamber in order to proceed with the request for financial record. In that case, could you provide an indication of how long from the issuance of such order it would take for the requested records to be provided? I know I'm asking you to speculate, so, but if you can even give us an indication or average number of days or months in order to process this kind of request, that will greatly help us.
I appreciate your question, Madam President, but I regret I would have to go back to my original explanation, which is this. The organs that would deal with a request of that nature are independent and autonomous. I don't control them. Nobody controls them. And if I received an order, I would pass it to the DPP pointing out our obligations under the law. But I cannot tell him, I have directed you to start tomorrow morning, and I have directed you to finish by Friday afternoon. I have no such power, I have no such authority, and nobody in Kenya has such an authority. If he went to a court, that court has its own docket. He can make an argument to the court to prioritize the hearing. The court is independent. The court can consider what he says, but the court is independent. Even if the court made an order, there is an appellate mechanism. I can't stop a person affected by such an order from preferring an appeal. The DPP cannot stop him. The Chief Justice cannot stop him. That process would have to go on. We have a Supreme Court. It has its own docket. If this person were to say that there is a novel point of international or constitutional law, and the Supreme Court decided that there was, neither myself, nor the Chief Justice, nor anybody else can interfere with the docket of the Supreme Court. Would it take a month, 6 months, 1 year, 2? I don't know, and I would not speculate.
Thank you very much. It's very candid and clear explanation, which I appreciate. Now, I would like to give the floor to parties and participants to raise any issue, including the points raised by my colleague, Judge Henderson. But again, I would like to remind you not to repeat previous written submissions. I'd like to start with prosecution.
I'm grateful, Madam President. In response to some of the things that my learned friend has said, I pick up first his assertion in response to His Honour Judge Henderson that the letter which he wrote on the 23rd of November of 2012 was his last word on the matter, that he'd invited the prosecutor, the ICC prosecutor, to go to court, and that hearing nothing more, he assumed that she was no longer interested in this material. Meanwhile, the attorney himself was quite clear that such requests had to be made by means of an order of the chamber rather than simply by a request of the prosecutor. Can I take, Your Honour, to that letter and indeed to what followed, because it demonstrates with the greatest respect to the attorney that what he's just said is quite inaccurate. The bundle which I provided Your Honours with this morning, the tabbed bundle, has that series of correspondence in chronological order. And the attorney's letter is at tab 10. The first thing I would observe is that the statement made by the attorney that certain portions of the request, RFA 45, the document which originated this whole dispute, had to be accompanied by a court order, is restricted to a tiny portion of the material which have been asked for. Can I invite Your Honours to turn to page 4? Your Honours see there that the attorney writes under paragraph little c, with regard to the request, and he's saying there, to freeze bank accounts. And he goes on to say that there needs to be a court order for that. I must emphasize that that request for assets to be frozen forms no part of our application today. I accept that the position of the government of Kenya in respect of that request has been consistent, but it's completely irrelevant so far as these proceedings are concerned. Now let us turn, if we may, to what the attorney said was the position of the government of Kenya on the 23rd of November with regard to all the other requests. That's at the beginning of this same letter. The requests for tax returns from the Kenya Revenue Authority. What does he say about that? He goes, I'm sorry, let me take it in turn. The request for tax returns, at para 1, then on the next page, records, bank accounts from the Central Bank of Kenya, post office savings banks, and other financial records. They're set out from 1 to 6. What is the position of the government of Kenya? Is it saying you must have a court order? The chamber must have authorized this? No, it isn't. It's saying on the 23rd of November, with regard to these requests, we have transmitted the request to the competent authorities, and we will revert as soon as we have relevant information. So far from it being the position of the government of Kenya, as I understand the attorney to say, that he'd closed the correspondence off in November. He'd said, you're not having this unless the trial chamber or the pre-trial chamber orders it. He was saying exactly the opposite, save for the freezing, which has got nothing to do with the case. He was saying, we're on the case, we're dealing with it, don't worry. And as for that being the end of the matter, and that at that stage, hearing nothing back, he assumed that the prosecutor, as he put it, was no longer interested, I shan't take you in similar detail, but tab 11, prosecutor writes back like a shot, 6th of December. I don't agree with you. You need to hurry up, please. I'm sorry if I'm using rather colloquial language, but that's the gist of what she's saying. On the 12th, at tab 12, on the 11th of December, the attorney writes back. He's aware that the prosecutor still wants this material, and indeed, in respect of certain requests, he says that they are carrying inquiries out. And in respect of the financial requests, his only response, once again, is to do with the freezing of certain assets. He says nothing to indicate that his previous assurances that these records, the records you, Your Honours, are interested in, were being obtained, is no longer the case. The prosecutor writes back on the 12th of December at tab 13. She restates her position. At tab 14, the attorney himself writes back. Again, he says, you can't have the freezing of the assets without an order. But he says nothing to indicate that the position of the government of Kenya has changed with regard to the financial records. And the correspondence continues, as Your Honours see, through February, and then into April, with the government of Kenya's filing, and culminates in June with the very clear statement of the government of Kenya in the filing which is at tab 18, which I've already drawn to your attention and will not draw to your attention again. But in essence, they're saying, yes, we accept the prosecutor has the right to make these applications. So the submission which my learned friend made is simply unsustainable. The correspondence didn't finish then. It was quite plain that the prosecutor was still highly interested in this material, and the government of Kenya had never stated that there needed to be an order by the chamber in order for the government of Kenya to comply. In fact, they'd said the opposite. They'd said, we're on the job, we're dealing with it, we will provide it. That's the first point that I seek to deal with. The second is this. The attorney, of course, has the advantage of all of us. He is not only a Kenyan lawyer, but he is also the senior law officer of the Republic of Kenya. And therefore he speaks with a certain authority when it comes to matters of Kenyan law and the Kenyan constitution. And I'm aware that there is considerable sensitivity about the proposition that non-Kenyan lawyers, particularly, it seems, those representing the prosecution at the International Criminal Court, try to interpret Kenyan law because it's suggested they're not competent to do so. I say all of that by way of proviso, because when His Honour Judge Henderson asked the attorney to comment upon, to elucidate paragraph 132(5) of the Kenyan Constitution, which sets out the President's duty, as I understood it, the answer which the attorney gave was, firstly, all the President has to do in order to comply with his obligations is to appoint independent officers, the important one, of course, in this case, being the attorney himself. And that is the whole scope of the President's duties. Well, I repeat the reservations. I'm not a Kenyan lawyer. But that appears to fly in the face of common statutory interpretation and indeed common sense. It can't possibly be the case that where you have a duty to ensure that the state of which you are a head complies with its obligations, its international obligations, you can discharge that duty simply by appointing somebody independent and saying, well, it's up to them now. Of course, your duty has to continue to ensure that that independently appointed person is actually doing the job. If he sits, as the attorney said a moment ago, on his hands and does nothing, it won't satisfy your constitutional obligation to say, oh, well, that's not my business anymore. If that is what is happening, then it is your duty, firstly, to stir him up into action, and if you can't do that, to replace him. And may I just focus for a moment on the word independent. I have no doubt that the attorney is a man of independent mind and that he does indeed exercise his functions independently and perfectly properly. But he isn't, in fact, independent of the President, as we can see from provision from Article 132, sub-Article 2 of the Kenyan Constitution. That is right at the beginning of the folder which I handed to Your Honours this morning. Immediately after the index, there are some selected pages from the Constitution of Kenya. And we're dealing here with the provisions of Article 132 and sub-Article 2. The President shall nominate, and with the approval of the National Assembly, appoint and may dismiss, who? Well, amongst others, the Attorney General. Now, as I say, I cast no aspersions. I'm quite sure that the Attorney does, in fact, perform his statutory duties perfectly independently. I'm not making any complaint about his independence. But ultimately, he is appointed by and may be dismissed by the President. So when he spoke of the President fulfilling his duties by by the appointment of independent persons to carry out the specifics of compliance, and nominated himself as one of those persons, it has to be borne in mind that Mr. Kenyatta has the power, firstly, to appoint him, and secondly, perhaps more importantly, to dismiss him. There's just one other matter which I wish to deal with. I'm conscious of the time. Just before I do, perhaps I can ask what might be called a scheduling question. Your Honours mentioned, or Madam President, you mentioned, that we will come to who said what. Now, I have dealt with a little bit of who said what, because it was raised by the attorney and I felt the need to rebut what he had said. But I make the strongest representations that in order fully to understand the context, it's important to understand who said what from an earlier stage. And I would appreciate at some stage, and if we're going to do it, it's going to have to be this afternoon, and I know that that was an unwelcome thought, but if we're going to do it, I would seek the opportunity briefly to take you through the correspondence, because it is extremely